Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss an important human rights case regarding death in police custody, custodial violence or torture by police. All these things can be discussed in this simple case. This is a landmark judgment given by the Honorable Supreme Court of India called as Nilabati alias Nilabati Behara case. You can see the case as Nilabati Behara versus State of Odisha 1993. The facts of the case are like this. Nilabati Behara, her name is Nilabati Behara. She is a small laborer woman in Odisha, in an area called as most like that is Sundargarh district she belongs to. Her son Suman Behara, who will be referred to as the deceased, on 1/12/1987 at about 8 a.m. early in the morning, the police came to the house of Nilabati Behara and picked up her son, Suman Behara. He was taken from the house by the ASI police of Bisra police station of Sundargarh district in Odisha. Right. So he was taken, right, immediately. Normally what they will do, the family members, they will try to search for him. They inquired in the neighboring police stations. The original jurisdiction police station, they said they did not know. Ultimately, on the next day, that is on 2/12/1987, at about 2 p.m., his dead body was found on the railway track near Jaraikela railway station. Right now, she alleged custodial death. Right before her eyes, while she was seeing, her boy was taken by the police, and they have identified the ASI also. But on the next day, his dead body was found on the railway track. Then she filed a writ petition. Actually, she moved around the police officers, she met the SP, she met the collector also, but since no justice was done, she was confident that her son died due to torture by police or in the custody of the police or police brutality. So all these words convey the same meaning. Now, ultimately, she filed a writ petition before the Honorable Supreme Court of India under Article 32. So ultimately, as a last resort, Nilabati Behara, she filed a writ petition. Of course, as usual, you may be knowing, this is a writ of habeas corpus. What do you understand by writ of habeas corpus? Means produce the person within fixed time before us. Normally, the Supreme Court gave notice to the state of Odisha. Right? Here, the important point to notice, the state of Odisha admitted that he was taken into custody. But while in custody, when he was going to be taken for the reconstruction of the scene of offence, since as per the police records, he was involved in a theft case. So in theft case, they have to do so many recoveries and they have to reconstruct the scene of offence to confirm whether he committed the offence, particular offence or not. Because during the interrogation, the criminal may be telling so many stories that he committed offence here, there, and normally out of over interest or anxiety, the police will be asking him, did you commit offence here? He will say yes, but normally he might not have done. So therefore, reconstruction of the scene of offence is necessary. Whatever it is, during the custody, he escaped from the police custody, and while running away, when he was trying to cross the railway track, he fell under the running train and lost his life. This is the defense story created by or narrated by the police of Odisha. But please remember, the contention or the submission of the state of Odisha was not at all taken into consideration by the Honorable Supreme Court of India. Therefore, they have ordered an independent inquiry by a committee of judges, that is district judge, PDJ will be one of the members, and along with them 2 members of the committee. So total 3, they will conduct an inquiry. Yes, the district judge conducted an inquiry as per the procedure established by law and also following the principles of natural justice, ultimately came to the conclusion, and he submitted a report on 4/9/91, that is after 4 years, stating that Suman Behara died due to the multiple injuries in the police custody. So when he received the injuries in the police custody means the police are responsible. Ultimately, placing reliance on the celebrated case, I will tell you that case also, Rudolph Shah versus State of Bihar 1983. The Supreme Court ordered compensation of 1.5 lakhs to the bereaved family, and also costs of rupees 10,000 or so was awarded for spending so much of amount in the Supreme Court. So please remember, this is a blatant violation of human rights. So normally the police will be telling such defense stories. Of course, it is for the court to decide, it is for the court to believe. But anyway, good judgment was given by the Honorable Supreme Court of India. This is a very good human rights case. So please remember the case, and whenever you get a question on this topic, you must be able to write Nilabati Behara versus State of Odisha 1993 case. Thank you very much.